Okay, Mr. Fraser, you're up.
Good morning, Your Honors. May it please the court, David Fraser on behalf of the appellants, Harry and Laura Criswell. I request to reserve 5 minutes of my time for rebuttal. The question central to this appeal is whether municipalities can enact regulations in ordinances over navigable waterways. What I refer to as a subject ordinance in this case is Naples Code of Ordinance 58, section 121, subsection 3, which says the side yard setbacks for all piers, including floating piers, pilings, vessels, moored to piers, boat lifts, and vessels supported on boat lifts, is 20 feet from the side property lines and riparian lines extended into the waterways. The appellants submit that local municipalities do not have the authority to regulate waterways or place setbacks into them, and boats engaged in navigation are outside the regulation of municipalities. Appellees disagree and say that they have the authority to place setbacks on navigable waterways.
Do you dispute that a municipality has the right to require permitting and code compliance when your client builds a dock into navigable water?
Yes, they have. I agree that they have the ability to have reasonable restrictions in place for dock building, and that's different parts of statutes.
Okay, and when you build a dock, you would agree that they can impose certain setbacks. So I can't build the dock on the border of my neighbor's property and then extend part of my dock into his property, correct?
I agree, that's correct.
Okay, so now we have a dock that you would agree that has reached its maximum length, right? 88.5 feet?
The dock, I don't know if the dock is at its maximum length. That really wasn't an issue below.
And then you have a 108-foot boat that is big enough to protrude on either side into the setback. Is that correct?
That's correct. It sits in the setback if the setback is able to be extended into the waterway.
Okay. And the navigable waterway you're talking about, really, I mean, let's be real, it's a canal.
No, it's a rather large bay.
Okay, it's a bay, but it has other residents who are able, by virtue of the ordinance, to navigate the deeper part of the channel.
I agree.
Okay. So it's your argument that the city has absolutely no authority to control any impediments to that navigable area of the canal?
Not any impediments, and this is what came up in the 5F LLC versus Dressing case, and they did this court did a very detailed analysis of it, and it says that it goes to the public trust doctrine that as long as a person is engaged in safe navigation, the city's it's off limits. And I can quote from those cases, if the court would like it, but it says that as a riparian owner, and actually I have broader rights as a riparian owner when I own up to the waterway. And if you recall in the 5F Dressing case, that had to do with the person who owned the riparian water, the water line, or the property adjoining the water line, wanted to wharf out into submerged lands. And the submerged lands owner, who was a private owner, said, no, you can't build a wharf in my land. And the second district, which was also cites back to Supreme Court case, the Ferry Harper's case, said, look, we need to look at the riparian rights. And the riparian rights of that landowner and the public are to engage in safe navigation. So as long as I'm engaged in safe navigation, the city cannot do anything. The dock issues, those are certainly, they can have safety regulations for docks. I can't go out there and tie up a bunch of old, pop cans and call that a dock. They can do safe regulation. The testimony below from the Naples.
But why? I mean, under the lights of your argument, why? I mean, if City of Naples has no constitutional, if it is constitutionally forbidden under the public trust doctrine and under the state's sovereignty over navigable waters, such that it is out of the regulating business, then who the hell is City of Naples to tell somebody from building whatever they want and tying off whatever they want?
I believe there's Florida statutes that give the city specific authority to require permitting for docks. I don't have the citation with me. I could provide it. But
okay, but your lead off argument is that, look, this is of a constitutional dimension such that the Home Rule Amendment just can't even be applied here. The city is without authority. So legislation that purports to grant authority to the city to enact reasonable regulations, and we can get into an argument about, you know, what kinds of, how boats are affixed to docks or not. That's a separate issue. But by the lights of your leadoff argument, that's all off limits, right?
The permit for the dock is under a separate grant of authority from the state, that the state allows you to ask for permitting information for the dock.
I get that. What I'm trying to take your leadoff argument, when what you actually led off with oral argument today, is that the city cannot do anything that abridges into the state's sovereignty over navigable waters.
Right, because here's the difference, Judge. Restricting somebody's ability to build a dock does not restrict their ability to navigate to and from in the manner that they choose, so long as it's a safe manner. So if the dock is 50 foot at the Criswell's house,
I think in order to close out my questioning here, I think I just need to hear from you. You're not really taking the argument that you're not really advancing the argument that the city of Naples is without authority as a matter of Florida Constitution to enact any regulation. You're not, are you advancing that argument?
No, and I'm not
Okay.
arguing that argument at all. And actually, there's plenty of statutes that give the city the ability to speed, noise, those types of other dangerous things. They can have a DUI ordinance and enforce that on the waterways. What I'm talking about is an ordinance that, without the safety concerns that the state, you know, as a dock, or the specific grant of authority from the state to say, look, we have a setback that we're enforcing in the waterway. They need to find a specific ability to regulate a setback on the waterway. There's no safety implication here for a setback on the waterway. It's just by the mere fact that they're the city, they said we're extending setbacks into the waterways.
And Mr. Fraser, correct me if I'm wrong, but the state of Florida was a party to this lawsuit for a time, was it not?
They were a party to the lawsuit and they were dismissed because we had, you know, it's not part of the record.
Did they assert a position? Did the state assert a position vis-a-vis the argument that you were making? They
asserted a position that it wasn't unconstitutional. And I don't know if not directly on that argument that there's specific grants of authority they can have. They just said that the Home Rules Power Act was not unconstitutional, which I don't think is a surprising position for the Attorney General's office to take. So if I start with the case law, that the focus of those cases, even in the 5F LLC case, they center on, is the vessel engaged in navigation? Those are the rights of the people to engage in navigation, and the city can't touch it. I move on from there to focus on the city's argument is, again, they don't have a specific grant to do this. Even to Your Honor Lucas's point, nobody can point to the statute that says the city is allowed to put setbacks in the waterways. If we juxtapose that with the 2009 legislative piece that the legislature commissioned Fish and Wildlife to do a pilot program, it's very hard to square the position that the city has the authority to put setbacks on the waterway when the legislature, through Fish and Wildlife, authorized just 5 municipalities to put setbacks on the waterways. They commissioned a whole 7-year study. Experts, the academia was involved in the study, researching the issue of how to implement setbacks on waterways. It was a broad consensus among the legislature that local municipalities couldn't do this, so they needed to set up frameworks to do it. If we look at Florida Statute 32760, there's 2 provisions that I cite in the papers, one subsection 2 and the other is subsection 3. In subsection 2, it says that this chapter 327 and 328 shall govern the operation, equipment, and all other matters relating to whenever any vessel shall be operated upon the waters of the state. I submit that as all vessels. It includes the subject vessel. It says that this chapter in subsection 2 does not prevent any ordinance, and this is a quote from the does not prevent the adoption of any ordinance or local regulation relating to the operation of vessels, except that a county or municipality may not enact, continue in effect, or enforce any ordinance or local regulation regulating the anchoring of vessels outside marked boundaries of mooring fields permitted to, as provided in 32740. It provides two exceptions to that prohibition on regulation: liveaboard vessels and commercial vessels, non-fishing. So again, if the city, as alleges, has the authority under the Home Rule Act to regulate all of those, why is this statute here, giving them a specific authority or actually prohibiting certain regulations except for liveaboard vessels and commercial vessels? Well, that's because those vessels are not engaged in navigation consistent with the public trust doctrine. If we move on to 32760 subsection 3, a similar prohibition on the city. It says, this section does not prohibit local governmental authorities from the enactment or enforcement of regulations that prohibit or restrict the mooring or anchoring of floating structures, liveaboard vessels, or commercial vessels, excluding commercial fishing vessels. So it says, this 327 and 328 say these are all the rules that will regulate the vessels engaged in navigation. And then under subsection 2 and 3, it has prohibitions. And in subsection 3, it says, except for, you can regulate floating structures, liveaboard vessels, and commercial vessels. According to the city, they can regulate all vessels. So this is a surplusage in the statute. Here, the legislature is saying these are the vessels you can regulate: floating structures, liveaboard vessels, or commercial vessels, excluding commercial fishing vessels. It would make no sense for the legislature to give municipalities a grant of authority here when they have authority to regulate all anyways. And what I submit to the court and what I started with is, what do all three of these types of vessels have in common? There are vessels that aren't used by the people to engage in navigation. The statute has a definition for liveaboard vessel. It talks about it has an address, it doesn't move regularly. Floating structure, it has a definition. And commercial
fishing vessels don't engage in navigation?
Well, so first off, it says commercial vessels excluding fishing. And the navigation I'm talking about is the right of the people to engage in navigation. And
right. And I think the statute you're reading from has to be understood by, by what it says, which is that it does not prevent the adoption of any ordinance or local regulation, which means that the state is recognizing that local governments and municipalities can regulate, but we're going to set up a narrow boundary of things that you can't regulate. And the question is whether or not Mr. Criswell's yacht falls within that. I think that's really what this boils down to, isn't it?
No, it doesn't. It's actually the opposite of that, Your Honor. Respectfully, it says this section, because the foregoing section I referenced is a broad prohibition on everything except certain classes. And then in further defining that broad prohibition, it says, look, you guys have been told this is all off limits, except for, don't interpret this to prevent you from regulating these three types. And it says you can regulate floating structures, you can regulate liveaboard vessels, and you can regulate commercial vessels, non-fishing. So the opposite is it. So long as my boat falls outside these categories, then they can't regulate it.
So your client doesn't have to abide by the City of Naples no wake zone?
Well, the no wake zones falls under a separate statute.
That's a city ordinance.
Right.
That's navigable waters.
Right.
I have to slow down.
And
I may not like it, but I have to slow down. The city of Tampa tells me I have to.
That was addressed in other cases, and I believe you'll find that in chapter 328, in which the state allows such things as no wake zones, DUIs. There's a specific statute on there where you have all these permissions.
Well, let's get back to the land, because you agree that a riparian owner has rights out to the water, to navigable water, correct?
I can even wharf into the navigable water so long as I do it safely.
Okay, so we agree. But you also would agree that the riparian owner is subject to city setbacks on his property, correct?
On the property, yes.
Okay, so if the riparian right owner has rights out into the water, those setback regulations still apply, correct?
No, they don't.
They stop at the water?
I would say
they stop at the water's edge.
They would stop at the water's edge because now
based on what?
But based upon the public trust doctrine, and now
Okay,
that
then let me give you this hypothetical. Let's say Mr. Criswell wants to build a huge dock, and he goes to the left of his property, 30 feet, 40 feet, 10 feet from his neighbor's property line, and builds an 88-foot dock that's a T-shape and blocks his neighbor's view of this beautiful bay. The city of Naples has no enforcement authority?
no, is again what we're trying, we're comparing,
Because the whole
setback.
problem here is this big boat blocks the neighbor's view. That's the complaint.
That was not the complaint below. Not at all was that ever raised below. The complaint is the city has police power and they're allowed to enforce it. That was what was argued below. There's been no evidence that this blocks the view, and in fact, it doesn't block the view. This is like, you know, the shape of this property, it blocks no views. Depending on the tide, you can actually only see about 60 foot of this boat, I believe it is, and it's well below the view line. But let me just answer your Honor's question.
Let me tell you, Mr. Fraser, you and Judge Sleet spoke into your 5 minutes that you were reserving for rebuttal, but use them as you wish.
I will. I'll just use 2 more minutes here. Just let me just answer this question. You're having setbacks combat with riparian rights. If the city wants to enforce a setback to cut away my riparian rights, then it needs to be on the basis of safety. And this is right out of this second district case in 2014, 5F LLC. That's what they analyzed. They said, is the restriction that you're looking to impose on my riparian rights, you got to balance it. Is it out of safety? If it's not, then they can't do it. The points that I'll make very quickly is that, look, if the statute gives the specific categories that they can enforce, they can't go after the other categories. If there's a specific prohibition on anchoring and mooring regulations against boats that are not, unless there are certain categories, we're not. They can't regulate the anchoring and mooring of that. I'll reserve the rest of my time for rebuttal.
You have about 3 minutes, Mr. Fraser. Okay, Mr. Donovan.
Thank you. May it please the court. My name is Chris Donovan. I'm here on behalf of the appellant and the appellee and the cross appellant, the city of Naples. I believe in the
and I'm glad you reminded me that there's a cross appeal. Do you wish to reserve some time for rebuttal on your cross appeal?
Yes, sir. 2 minutes.
Okay, great. Go ahead.
Thank you. This case boiled down to its essentials is really quite straightforward. The question is the city's setback law valid? And if it is, then is the city entitled to a permanent injunction from its violation on mere proof of its violation? And the trial court answered the first question in the affirmative and the second question in the negative. In other words, the trial court recognized that the law was valid, but refused to enforce the law because supposedly the evidence was it wasn't harming anybody. And I think before delving into my argument, I just want to correct that last point in the exchange between Judge Sleet and Mr. Fraser. There was a complaint, and that was borne out in the record. And in fact, I believe the trial court had resolved that by the summary judgment stage, that there was somebody had complained, and that's what kicked this whole thing off 3 years ago with code enforcement, and then a variance action, and then the denial of variance, and a petition for cert, and then the filing of this lawsuit, and the filing of another lawsuit that's pending in federal courts. I mean, that complaint is what kicked this off, was that it was blocking somebody's view. Delving into the argument of the validity, there is nothing in the public trust doctrine that expressly preempts the constitutional home rule powers of local governments to concurrently regulate with everything that the Florida legislature can regulate on, including zoning and riparian rights. The case law is very clear that express preemption must be unequivocal. If it requires any implication or inference, then it doesn't apply. In fact, this court's Phantom Fireworks case specifically said that it has to say, quote, everything in Chapter X shall be preempted to the state, or the state shall have exclusive jurisdiction over the matters in Chapter X. The public trust doctrine doesn't say that. It only concerns really the title to the navigable waters, and from that they imply that includes exclusive control. And then in the appellant's reply brief, they attempt to twist the city's argument into a tautology. the appellant essentially argues that the city claims that there is a conflict between the constitutional public trust doctrine and the Constitution's home rule authority, and that this conflict somehow necessarily creates an express conflict, because if there's a conflict, then home rule has to give way. That's not even a correct legal notion. Express preemption and conflict preemption are two different things. And that's certainly not the city's argument. The city's argument is the Constitution gives local governments home rule authority to concurrently legislate on everything that the legislature can legislate on, unless expressly preempted. And the public trust doctrine, the city has not said that laid claim to the title to the navigable waterways, which is what the public trust doctrine provides for. If that's what the city had done, then certainly there would be preemption or conflict of some sort. But that's not what the city has done here. In fact, I think it's worth emphasizing that the city is not really regulating the navigable waterways. Nothing is preventing the Criswells from taking their vessel into the lagoon and traveling around the lagoon, or even accessing their property. The only thing that the city is regulating is zoning. They're regulating the use of the property, as both Judge Lucas and Judge Sleet pointed out. A use that has been traditionally been within the purview of municipal law, including the ability to regulate the construction of docks, as well as and this would include the regulation of balancing a riparian right of access to your dock via a vessel, as well as the riparian right to an unobstructed view of the water. And that is the only thing that the city is regulating. And the appellants have cited not a single case suggesting that local governments do not have concurrent authority to regulate the mooring of vessels to a pier or dock behind their house. In fact, this would be quite monumental, because it would mean that the cities would not have concurring authority to regulate things such as surfing or skimming on the beaches, or charging a reasonable fee for driving on the beaches if we still had that, or regulating dogs on beaches, or the Florida legislature wouldn't have been able, in one case, to give the county the veto authority over submerged leases approved by the Board of Trustees of the Internal Trust Fund. All of these are matters that have been resolved by the Florida cases.
Well, Mr. Donovan, what about the expressio unius argument about how you interpret 327-60 sub 3, which says this section does not prohibit government authorities from restricting the mooring or anchoring of floating structures, liveaboard vessels, or commercial vessels, excluding commercial fishing vessels. Can you address that briefly?
Sure. Two ways, Your Honor. First, they argue that in respects to express preemption, and it can't be express preemption because by definition,
there's nothing in the statute that expressly preempts, right?
Right, and it's requiring an implication. That's the plain. I love that phrase, the Latin phrase, but the plain English canon is negative implication canon. It's implied in the canon. The second reason is that generally that canon, first off, it's not a rule of law, that canon, and second off, it doesn't apply in every situation. In fact, there's one court that says that suggests that there's a phrase about it not being the master of interpretation or something like that, or controlling all interpretation, and it generally does not apply when talking about legislative power. And that reverse canon or contrary canon has been applied to local governments as well. In other words, if there's already a authority to legislate on something, as there already is in home rule authority.
Yeah, you go back to the home rule amendment is basically where you land, right?
Correct, Your Honor. And there's many instances where the legislature has still said, yes, cities can regulate this, but that power source isn't coming from them. It's coming from the Constitution. I mean, chapter 166, I think it is, where they actually say, oh, they have home rule authority. If you were to remove that whole chapter, the city would still have home rule authority. If you were to remove subsection 3 of 327.60, the Constitution would already allow for the city to regulate those same things that have been identified. So at best, what 327.60 3 is a clarification that since we talked about possibly regulating these things in subsection 2F, we just want to make it clear that we're not saying you don't have authority to regulate these things otherwise. But 2F, which is the exception that the Criswells are relying on, let me back up for a moment. Section 327.60 also doesn't contain any express preemption. In fact, it states just the opposite. It says, go ahead, governments. So we're not saying nothing in 327. Local government says you are prevented from regulating navigable waters or riparian rights, except for very limited circumstances. And one of them is regulating anchoring of vessels outside mooring fields. Now, earlier this year, the Florida Supreme Court reaffirmed that in interpreting legal texts, the supremacy of the text controls. And generally speaking, other cases have recognized that exceptions are construed narrowly. Well, regulating anchoring is not what the city is doing. In fact, it has not regulated anchoring. It is regulating, at best, the mooring of vessels behind somebody's private dock. Anchoring and mooring do not mean the same thing. They're not synonyms. In fact, there's no Florida case talking about this, but in the brief identified several federal cases that rejected very similar arguments, because anchoring can be found anywhere. It can happen anywhere. It can happen during travel. It can happen in the middle of the navigable waterways and in unexpected places. So the safety measures are certainly going to need to be more uniform and more consistent throughout the state, which is probably why the state has subsection 2F concerning anchoring outside of mooring fields. Whereas mooring is attaching something to a fixed object, typically a dock, and it's usually a permanent stationary instance. So mariners are expected to navigate around it or otherwise know where these permanent mooring vessels are. So anchoring and mooring are not the same thing. And nothing in 327.60 expressly preempts the local government's setbacks law concerning that. They've also suggested that Chapter 327 implicitly preempts setbacks law. Again, this court's Phantom Fireworks case, the Supreme Court's Fair Elections versus Browning case, both of them recognize that implied preemption is generally disfavored. It's exceedingly hard to show, and because courts are hesitant to take away or assume that the legislature has taken away the home rule authority. In fact, Browning is, I think, a very applicable case, because in that one, it involved whether or not the county in their election, they had a couple of election charter provisions that they were putting up for a vote that concerned the local elections. And the Supreme Court said that nothing in the Florida election code, despite how detailed it was, evidences an intent in its provisions, its object and purpose to impliedly or even expressly preempt local governments concerning elections. And a year later, the Florida legislature corrected that. They put something very specific in there. And then there's another case, I think it's Orange something, or it's a case that went back before the Florida Supreme Court. They said, yep, there's the language, it's in there now. Well, that may happen in this case, but that hasn't happened yet. And currently, the local governments do have authority, and nothing in 327. And I want to point out that they do not attempt to draw any implied preemption in the language of 327. Instead, they look to a repealed statute, a fish and wildlife study that was commissioned by the legislature in the repealed statute that didn't change anything. And they look to legislative history, which at the bottom of the legislative history specifically says it's not the opinion of the Florida House of Legislature or the Florida House of Representatives. If it's not their opinion, it's certainly not the opinion of the entire legislature. Therefore, the fish and wildlife study, the repealed statute, all of that is irrelevant. And it doesn't apply.
So, Mr. Dominus, assuming the city of Naples is on solid ground, so to speak, in terms of enforcing its setback out in riparian rights, on your cross appeal, there's the question of, well, what remedies does the city have available to it? In reading through this, am I correct that not only is the $500 a day fine it's available, but that the city never sought to impose it?
Yeah, that is correct. The city, well, it's partially correct. I don't want to say the city never sought to impose it. Originally, and I believe this is all within the record, the code enforcement provided a citation. We were asked to hold off on code enforcement proceedings to allow Mr. Criswell's to obtain a variance. And they went through the variance process and were denied. And then during that process is when they filed this lawsuit. So since it was already teed up in the court of litigation, they went ahead and we counterclaimed for an injunction to enforce it in court. So it hasn't been, the process started, but it didn't complete in terms of doing the 500-day fines.
Okay, all right. Well, I guess that was a decision that was made, but it does kind of leach into a little bit about a concern I have about an argument you're making on cross appeal, and you alluded to it actually in your kind of your opening statement, which is, are you really arguing that a court in equity, when a judge is sitting as chancellor in equity, has no discretion but to grant an injunction whenever there is a violation of a code ordinance or city regulation?
If it's proven that there is a
Well,
violation,
assume that.
assuming
that goes
that
without saying. Assume that that it's proven that the chancellor in equity cannot consider anything else, no matter. Let's say, for example, that the Criswells are able to bring evidence before the judge. Hey, judge, in fact, this boat, when you do all the measurements, it's 1 foot that comes over into the setback. And oh, by the way, there's 20 other violators, but it looks like that this code enforcement officer just has I'm not saying this is in the record. I'm giving you a what if, that this code enforcement officer just has a thing against me and against Criswells and is trying to put the heavy hand of the government onto us. Are you telling me that that in equity, trial court could not consider that? It has no discretion. Somebody violates the law, it's ipso facto injunction has to take. And I'll take this to an extreme. Suppose somebody builds a skyscraper 1 foot into a setback. The chancellor is without discretion but to order an injunction to have that skyscraper torn down.
Your Honor, I mean, I can't say that there's not affirmative defenses that were or could have been raised, but in terms of the case law, there's at least 3 Florida Supreme Court cases and 8 District Court of Appeal cases, 4 of which are from this court, that say, and I'm quoting from one Supreme Court case, merely alleging a violation of a zoning ordinance is sufficient on its face to justify the injunctive relief. That one need not prove irreparable harm or adequate legal remedy, which is the only issue before this court. It's the only basis of the court's discretion.
See, in my mind, those are discrete issues that probably ought to be kept separate. Whether the proving of the irreparable harm is one facet of injunction, and I get it. I totally understand. The case law is very clear that when there's a violation of an ordinance, you're entitled to a presumption of some sort that irreparable harm has been shown. Fine, you got that element. But the ultimate granting of injunctive relief is an act of equity. I mean, that's what it was grounded in. That's what it's been for hundreds of years. Does it really mean just because you've shown this one facet of injunctive relief that, oh, you're entitled? You now, not only are you entitled, but the court has no discretion. It has to give it to you.
Yes, Your Honor, because one of the first principles of equity is equity follows the law. And the law is the setback law. And therefore, the trial court does not have discretion not to follow the law. So if the
but here's the thing though, and this goes back to why, and I'm sorry for taking up so much time on this, but this goes back to what I opened this with, which is the $500 a day fine and the lien rights that the city of Naples has on this property if it fails to pay it. Injunctive relief is just that. It's a form of relief. It's a way of fashioning a remedy. And equity is meant to fill in those cases, and it's meant to be malleable and so that it can respond to different circumstances. Here, the city hasn't even tried to get this guy into compliance by the old-fashioned, hey, we're going to fine you. We're just going to fine you. At a certain point, you're not going to put that boat there anymore. As opposed to the heavy hand of the government saying, thou shall not do this with your property, which is categorically different than fining him for something.
Yes, Your Honor, but you're now talking about whether or not there's an adequate legal remedy. And with respect,
no, I'm talking about whether the judge ought to have discretion.
And I mean, the case law doesn't bear out that they do have that discretion, and that discretion would come from whether or not there's an adequate legal remedy, which the case law has said is not required to be looked at. And the Florida legislature has basically said the same thing in Chapter 162 in 3 different provisions, saying that the proceedings in code enforcement and their remedies are merely additional or supplemental to any other means that the trial court, I'm sorry, that the city can enforce its code. Therefore, I don't think that there is discretion. In fact, this court's Polk County case basically said that with respects to prohibitory injunction.
I've read the Polk County case. I'm familiar with that line. I'm not sure that that line that is in there about the lack of discretion was needed in order to grant the holding, since, correct me if I'm wrong, that case was basically a trespass onto city property, correct? The guy was posting signs onto city property. All that he said was that it was a trespass and was being enjoined, right?
But under your scenario, then if it's not hurting anybody, the court should have discretion.
No, don't misunderstand me. Don't misunderstand me. All I'm suggesting by bringing that up is these are things that, okay, maybe you show that maybe the city has shown, checked all 4 boxes, and it's entitled to a presumption on one of them as soon as it shows that an ordinance is violated. So the government already gets a nice head start on this. Mm-hmm. All I'm saying is that what should prohibit a trial judge sitting in equity from considering other facts, such as in your record, where basically your code enforcement officers are admitting this isn't hurting anybody, it's not causing any harm, it's not a problem.
Hey, you and Mr. Donovan, you and Judge Lucas have come to your rebuttal time on cross appeal.
And you have my apologies, because I've been very talkative on this case.
Enjoy the robust discussion. If I have any time left, I'll retain it or reserve it for rebuttal.
Yeah, I'll give you the 2.
Mr. Donovan, Mr. Fraser.
I will charge some of that to Judge Lucas. So
well, I get charged too. Mr. Donovan, Mr. Fraser, you're both doing a great job. This is
absolutely.
So go ahead.
And I can talk very fast, so I apologize. Judge Lucas, following up on the court does have discretion. And what is important to recognize here is Florida section Code of Evidence 302, it's a rebuttable presumption. That's why I did a trial, I rebutted it. They said it was no harm. If you look at the cases that council or the city cites for this idea that it's set in stone presumption, each one of those cases dealt with, and they don't talk about it on any evidence rebutting that presumption. If you look at the State versus Sam Scott case, that was dealing with obscenity and the obscenity statute that in its own language, it says upon showing of an obscenity, the court enters injunctive relief. If you look at the Hernando case versus the Galaxy Fireworks 5th District case, the city cites that as saying, look, because there was a violation, therefore, because the trial court had doubt of a violation, therefore it could not enter an irreparable injury. That's wrong. The Hernando case uses or. It says it had a doubt of irreparable injury and it had a doubt of the violation. So these are 2 separate issues. Federal courts have addressed this. We cannot combine those. There might be a presumption there, but those elements, violation and irreparable injury, still remain separate elements that you have to prove. They don't get merged because it's a city. They get the presumption, but I'm entitled to overcome that presumption, what I did. Judge Sleet, the other thing that I would point on, and I know Judge Lucas and Judge Sleet, you guys have tried a lot of cases, Judge Sleet, a ton of cases. The city's complaint, we point this out in our brief, asks for an injunction against docking. The statute says mooring. Today they're here picking nautical terms apart. If I can't use nautical synonyms for defining the statute, they shouldn't be allowed to either for the purposes of pleading. They pled a complaint seeking an injunction for docking. There's no law in the city of Florida that prevents docking. And then Judge Sleet, your other concern about where does the authority come from the city to enact ordinances on speeding, those types of things, that's 327.46. It goes on to say a municipality may enact these things, speed limits, those types of stuff. I submit to the court that chapter 327 and 328 is the Bible. It's the Torah. It is the Quran when it comes to regulations of boating on public waterways, and the city cannot go in there. The rest of the issues, the city is appealing the denial of a summary judgment, looking at an issue of fact. I filed a supplemental authority that says you cannot do that. It must be an issue of law. The facts at trial were not good for the city when their city investigator said, everybody's doing this. It causes us no problem. It's very low priority. I have to imagine I'm out of time at this point, but I would just end with the 5F LLC versus dressing case. The city here's argument is that they were given general authority to enact because they haven't been told no. If so, our Supreme Court says that is a abdication of the state's responsibility to enact regulations, and just like any other trustee, the trust res is navigable waterways, and they are responsible for controlling it. For those reasons, I would ask that the ordinance be deemed unconstitutional. I'll rely upon my briefs for the implied preemption. And yes, Fish and Wildlife was, the statute was repealed, but by its natural course. The statute enacted Fish and Wildlife to do a report. They came back with the report and it was done, and they moved along. So the Fish and Wildlife report reference, why would Fish and Wildlife give 5 municipalities the ability to do this if they all could? For those reasons, I would request that the injunction denial be affirmed, but the ordinance be deemed invalid.
Great. Thank you, Mr. Fraser. Mr. Donovan, you got your 2.
Yes, thank you. I just want to point out that there is really no case that says that this is a rebuttable presumption. There is, however, cases that say it's established. Don't have to prove it. It's established beyond reasonable doubt. No need to present proof on it.
Well, Mr. Donovan, what about this point? Because Mr. Fraser brought up something about pleadings. As I read the city's, I think it was their counterclaim, paragraph 26, you all tied the theory of what you wanted in count 2, I think was permanent injunctive relief. You all tied it to the injury that it was causing to the public. He says the Criswell's continued violation of section 58.121 sub 3 is injurious to the city residents and the general welfare, including the welfare of abutting neighbors, by keeping the yacht from interfering with riparian right to an unobstructed view of the bay. That was the flag you all flew in on this. At what point did this get amended to include your broader theory now that, hey, it's a violation of the setbacks, therefore we get an injunction?
I'm not sure. I mean, I understand your question, but I'm not sure that we did change our theory or have a broader theory. I think that we proved that certainly at the summary judgment stage that somebody had complained, and that complaint is part of the reason why we brought this, or originally filed the citation, or gave the citation to the Criswells, and then what kicked this whole thing off. The arguments that, I mean, I guess I'm not entirely sure I understand your question. I mean,
Sure, the basis, as I read your pleading, your pled basis for permanent injunctive relief is that this mooring of this yacht is harming neighbors. It's harming their riparian rights.
Yes, Your Honor.
And so if the trial court concluded, I don't think it really is, you're stuck with the, then really you didn't put the, you violate the ordinance, therefore we get an injunction in the pleading. So therefore, if that's not brought, you see that's my concern.
I mean, we did. We said in there that they were violating the setbacks law, and part of the harm is that it's impeding somebody's view of the water, and implicit with that is the case law. I believe it was the Phil Broad or whatever Supreme Court case that says that the mere violation of the law is the harm to the public. So, I mean, I think we've kind of encompassed that.
What you're saying, Mr. Donovan, is that you pled more facts than you needed to.
Correct. Yes, Your Honor.
Right.
I elaborated maybe too far, but we certainly.
Yeah, right.
Yes.
Judge Lucas has done it again. Your 2 minutes are up.
Okay. Well,
I'm just going to mute myself now.
You guys did a great job arguing an interesting case.
Yeah.
Thank you.
On both sides.
Thank you, Your Honor.
In order to leave this virtual space, you need to click the